Adjournment request, if any, from item number 1 to 5. From item number 6 to 58. From item number 59 to 63.
Wait, please, my lord. I'd like to mention item number 59, my lord, with the consent of the other side. There's been a change in the council, my lord, in this matter. So I may pray for a short adjournment today.
9. Yes. You know,
We'll be taking consent from the other side.
urgent.
The Lordship, with the consent of the other side, I beg to mention item number 62, Lordship.
Yeah.
Yes, sir.
Not Lordship, leading council, he has some difficulty today, may be listed on some other day, Lordship, after a week.
Urgent.
Public.
May it please your lordship. Lordship, I beg to mention item number 6, your lordship.
6.
Lordship, I can be adjourned the matter for 2 weeks, your lord.
Yeah.
6 and 7.
6 and 7.
Both. Who is appearing for the other side?
Other side, lordship, Mr. R. Dubey appears, your lord.
You informed him.
I've informed lord.
Urgent.
May I please your lordship? Lordship, I beg to mention item number 8, lordship.
Yeah.
Due to medical grounds, engaged counsel is unable to appear, lordship. So kindly matter will be taken after 1 week, lordship.
Urgent.
Obliged.
Any other request?
May it please your lordship. Lordship, I beg to mention for listing of a read appeal on 28, my lord. 28 of August.
Urgency.
My lord, the order of the honorable single judge is of 14/8/2024, my lord. And by that judgment, the honorable single judge has asked the authorities to consider the deed of the.
You filed that appeal.
We have filed, my lord.
28.
Obliged, my lord.
May I please, your lordship? No, I beg to mention a matter which is in the hearing category. The lordship had on the last date given me time to file a response and also directed that the matter be listed after summer vacation. I request if a specific date can be given. Lord, I'm outstation.
The registry is not given any specific date.
And
Take
not yet.
the date from the registry.
I'll do that. I'll do that.
The registry will give you the date, specific date. You go and ask for that.
I will do that. Obliged.
Daily list for orders, item 1 to 3. Item 1 and 2.
Respondent number 4 was supposed to file an affidavit.
Lordship, in PL 6, Lordship, I am appearing for the respondent Social Justice and Empowerment Department, Lordship.
PL number 6.
6, Lordship.
Okay.
Here, I seek for some time, Lordship, for filing affidavit, Lordship.
By the way, what is the role of the Social Welfare and Justice Department?
Lordship, your Lordship is directed to frame the policy regarding the employment, selection and employment of the transgender. So
Yes.
for that, Lordship, some time is required, Lordship, as per my.
Oh, is there any policies under deliberation or what?
Lordship, yes, policy is under deliberation, Lordship.
So far as the policy is concerned, your lordship may just have the Assam state policy for the transgender. And that policy is quite relevant in this aspect.
Will submit-
They already have that policy.
Okay, then
So within that policy framework, the state departments can proceed further for inducting the evolving principles.
that's why only we are asking to file a reply for that.
Yes.
Okay. And item number, PL number 6 of 2022, and a consent appearing for the respondent number 4. Pay some more time to file response to the PIL petition. How much time?
Lordship, 4 weeks time.
4 weeks, it's too much.
Lordship, policy decision.
The policy decision, whatever it may be, that policy is already in vogue. You have to
Because
give a
that is-
mechanism for that, for applying that policy.
The Assam state policy has
That has
already
to
been
be-
approved by the cabinet.
3 weeks,
Lordship,
3 weeks.
And so far as the PIL2 is concerned, we have received the affidavit.
Fine.
But the affidavit is discloses the various meetings which have been taking place within the welfare board. But so far as the establishment of the welfare board office is concerned, that is still silent.
Who is for in respondent number 2? Who is appearing in the respondent number 2?
PIL two.
PAL 2, who is appearing for the respondent number 2? Or which respondent you are asking for? In PAL 2, who is appearing?
Lordship, I am appearing for the respondent social justice and empowerment department regarding the setting up of office. Office has already been set up in Titio Nibas, Lordship.
Inform her.
Lordship, we will, Lordship.
Inform the petitioner that it is set up here, this is the address,
Yes, Lordship.
and this is the person in charge.
Yes, Lordship, we will.
Yes, when, yes, inform him right now. If it is that's there,
Lordship, regarding that, Lordship, we have already stated in our affidavit that an office has already been set up in Titio Nibas, Lordship.
where is that? The location of the office.
Lordship, address, Lordship.
Actually, address, who is the person who, in charge of the officer?
Yes,
Your
Lordship.
lordship, interestingly,
That-
just your lordship,
Lordship, kindly give me 1 week time, Lordship. I will clarify all the.
your lordship,
Objection
before
is filed.
granting the 1 week time, if your lordship may pursue their affidavit, just for once.
Yes,
The last second page of the affidavit.
affidavit dated.
Kiman dated kiman asile affidavit? The affidavit has been signed by Bhaskar Jyoti Manta. If your lordship has found out,
Yes, Bhaskar Jyoti Mamta, that is.
yes, the
13th of
second,
August,
the
13th of
the
August,
second last page, the annexure with this affidavit.
yes.
If your lordship may just see the serial number 4. Approval for office of the Transgender Welfare Board.
Fine.
Here it is written, the resolution
as proposed.
approved as proposed to set up the office urgently, including supply of items and logistic. Director Social Justice and Empowerment Assam was requested to initiate the step. And this is the minute of the meeting dated 12/6/2024.
Principally, they have decided to set up a office, this office of the transgender welfare board.
Only the
Whether it is
resolution,
It is actually set up or not?
no, not yet. There's only the resolution has been taken.
Already office has been set up and furniture has also already been procured. Lordship.
And the person in charge or any other person has already been also been appointed.
Lordship, the new board of the transgender welfare board has already been constituted and they are functioning from that office. Lordship.
There is also a difficulty in that welfare board because the previous member who were in the welfare board, they were never been informed that the tenure has finished. Never the handing over and the charging over of this board
They
take
have
place.
already established the office for that purpose.
Not yet.
Then when is
This
the
only the
function of-
resolutions have been taking place. They are purchasing the furnitures, but no any transparent office till there.
Lordship, we have also-
Clarify this point.
Lordship, I will clarify this. Lordship, Lordship, kindly give me 1 week time. Lordship.
List along with this only. Okay. The Director of the Social Justice Empowerment, in this item number 2, the PAL number 2/22. Director of the Social Justice and Empowerment Department has filed an affidavit on 13th of August 2024. Along with the lead affidavit, the minutes of the meeting of the Transgender Welfare Board held on 12/6/2024 has also been annexed. Learned counsel for the petitioner has submitted that though though in the meeting dated 12/6/2024, it was decided to set up an office office of the Transgender Welfare Board, but actually the same has not been taken shape till date. Full stop. Learned counsel for the Social Justice Welfare Department, Social Justice and Empowerment Department has submitted that that the office has already been set up. Office of the Transgender Welfare Board has already been set up and required logistics has also been provided. Full stop. Learned counsel for the learned counsel Mr. So raised some time to furnish the details about the address and the other relevant information regarding the Office of the Transgender Welfare Board, which for time frame for is granted. List after 3 weeks, along with this PA number 6 of 2022.
For admission, item 3.
Lordship, I have inspection to withdraw this matter, Lordship.
Fine, that's.
Lordship, if possible, cost part may be interfered with, Lordship.
First part, it's really on a lesser side. We have already mentioned that.
Lordship,
Deposit the cost.
since we are not pressing the matter, Lordship.
Not pressing the matter, that is our insistence, not on our own volition.
Lordship,
That is, there is nothing but a harassment. This is to be deposited with whom?
Lordship,
This 50,000 cost is deposited with whom?
not deposited, Lordship, since we have filed this,
Guwahati High Court Legal Aid.
legal,
Committee.
illegal.
That's good. Guwahati High Court Legal Aid Committee, naturally, we need some funds. Deposit that.
Okay.
And it concept of the appellant on instructions has submitted that he wants to withdraw this writ appeal. However, the time granted by the full stop in view of the however, she played that the cost imposed by the learned single judge while impugned order be made easy. Stop. Having taking into consideration the fact that the appellants have decided to withdraw the appeal without contest, we deem it appropriate to reduce the cost of rupees 50,000 imposed by the learned single judge and direct the respondents to deposit the cost of rupees 25,000
That's it.
before the Guwahati High Court Legal Aid Committee within a period of 4 weeks from today.
That's it.
Your Lordship, if I may state, it should be appellants, Your Lordship.
Yeah.
Appellants, Your Lordship. Highly
Okay.
obliged.
IA number 7.
Item 4.
My lord, we have taken instruction from the client.
Yeah.
My lord, our instruction is to contest the proceeding. The only thing is, my lord, they have, in the writ petition, they have brought out certain factual aspects. Would like to file a small affidavit. Possibly kindly give us small, a little time, my lord.
Lordship, in fact, whatever has been filed before the tribunal, whether it is his OA, my counter, his rejoinder, my additional affidavit, his written argument,
That you.
all are on record. And I have not taken any new document or any new fact in any case.
Short about,
A week's time may be given.
we'll fix it on 27th or 28th,
If Lordship could
as
take
per your convenience.
and 29th, if Lordship, if it,
Could it be on following week, my lord, a month, following Monday?
the only problem which are facing Lordship, because of him, we are unable to transfer the person who has to replace him also. So we are awaiting the entire system
In
is,
this case,
My lord,
that
there is
nobody
nothing
is
like this,
transferred.
my lord.
Nobody is transferred.
One who appears for the authority, they always make such submission. The heaven is not going to fall, my lord. 27th, 8 persons.
I
have
don't
been
know what is
discharged.
the heaven for each of us.
Please don't go into all this. 1st of September?
Yes.
It's a good day. My birthday is also first.
Oh, that's nice. Happy birthday in advance.
First is Sunday.
Acha, first is then you please enjoy your birthday on Monday and we'll have it on following day.
Second.
Second of, no,
PK Leonard, Mr. Chaudhary takes some time to file a short affidavit in support of his submissions. To stop. Is this matter on 2nd of September?
Deep development.
But
Item 5,
May I please, Your Lordship? In this case, the arguing counsel is from Kolkata, Lordship. We applied for the link, but because of the technical problem, he could not connect, Lordship. I paid it, the matter will be taken after some time or on another date as well.
Nimish Menon. What is the name?
Abhishek Banerjee.
What is the name?
Abhishek Banerjee.
Let me taken up any other date.
Whatever date as per your coming.
Yes, they are from Calcutta, I think. They are from the council from Calcutta. So when it is possible?
As per your.
No, these are from Calcutta.
He has to
Online.
appear.
That's why. Don't put on 13th, it's okay. Tenth is okay.
10th of September, Lordship.
At the request of the learning council for the parties, this matter on 10th of September.
For hearing, item 9.
May it please, Your Lordship. This repetition has been preferred, Lordship, challenging a single judge order, Lordship. That is on page 70. On page 72, Lordship, paragraph 7.
Just a minute, please. Where is the decision of that director?
Page 36, Lordship.
What proof you have submitted before the director?
Lordship.
What proofs you have submitted before the director?
Lordship, I did not submit anything, Lordship, but my Lord,
You have not submitted anything.
Lordship, but my
Why?
Lord,
The opportunity was granted to you. Why you have not submitted anything in support of your claim that you are the resident of this center number 4 of Sadargaon Reserve, Chubri Mini Anganwadi Center?
Lordship, only thing is that, my Lord, I have taken the stand in my affidavit in opposition that, my Lord, no proper opportunity has been given to me, Lordship.
That is there,
The
sir. The
report-
date was fixed on, hearing was fixed on 24th of this March 2015. You appeared before.
So I have taken the stand that the report has been prepared behind my back, Lord.
Which report, sir?
Report submitted by the program officer, Lord.
It's a survey report. That was a survey report.
Lordship.
And that's why on the basis of that survey report, you were asked to submit your explanation.
Lordship.
Because that survey report says that you are not you are not resident of that center number 4.
Lordship.
That's why only you were granted opportunity. Then what documents you have submitted?
That is not with me, but in the writ petition, I have annexed 4 documents, Lordship, 4
Which 4
certificates.
documents? Okay, yes.
Lordship, that is annexed 6 series, page 38. It is
38.
Lordship, certificate issued by Gaubura, Lordship.
This is to certify that the wife of that resident of the above mentioned resident of my village are not person. Yes, Sadar, now no doubt
Lordship.
you are resident of that place.
Then, my lord, page 40, it's submitted certificate of ward member Nilbagan Gaon Panchayat, page 40, Lordship.
I am elected Gaon Panchayat member from so and so ward number comprising of Southern Gaon Village, part of so and so. Permanent resident of Southern Gaon Village area. Mamta Dexter, wife of so and so. Yes, that's right.
And
Where it certifies that you are the resident of Anganwadi Center number 4. area of the Anganwadi center number 4. Where is that? Which is that document?
Page 42 is a president certificate, lordship, here it is written that, my lord.
Certificate 20 family residing so and so 24. Or Southern Reserve Amity Jama Masjid. That's right. Where is that certificate that she is resident of ward number 4 only?
The Anganwadi center is situated in the Sadar Gaon
There are
Reserve
two
Forest area,
Anganwadi centers.
lordship.
One is center number 4 and another is center number 5, 85.
Lordship. Even, my lord, the page 63, that is the report of the program officer, here also written that,
63.
kindly have a look at paragraph 2, lordship, page 63,
63, yes.
lordship.
Yes.
The resident of Farida Begum, that is the appellant, wife, village Sadargaon Reserve Subri Anganwadi Center. Here it is written, lord.
The resident of Monta, the survey area.
Next line, lordship, her house is under the survey of another Anganwadi center.
Her house is number 48 at serial number 271 flag A. The residence of a resident of Farida Begum, Pipri, her house is under survey number so and so. Her residence is at 85 number Sadar Anganwadi Center, which her house is number so and so. Farida Begum running the Anganwadi Center near 85 no Sadar now. But not running the proposal locating Sadar now, her house is nearly 2.5 proposed from the Anganwadi. Depends.
These are the only documents, lordship.
Documents are, doesn't certify that you are the resident of Anganwadi Center number 4.
Not.
This writ appeal is filed by the with the order dated 25/11/2020, passed by the learned single judge in writ petition number 2997/2015, whereby the writ petition filed by the petitioner has been dismissed. The brief facts of the case are that the petitioner and the respondent number 6, lordship. Respondent number 6 in this appeal. The respondent number 6 herein have appeared in the selection process of Anganwadi worker for center number 4 of Sadar Gaon Reserve Mini Anganwadi Center Nagaon, pursuant to the advertisement dated 27/1/2014. It's stopped. The respondent number 6 has challenged 2014 in the said selection proceedings pursuant to the said advertisement. The appellant was selected as Anganwadi worker for the center number 4. The respondent number 6 herein has challenged the selection of the appellant as Anganwadi center for the center number 4 on the ground that she is not resident of that area. Full stop. She, the writ petition preferred by her as writ petition number 4580/2014 was disposed of by learned single judge of this court by the order dated 10/9/2014 with the direction to the director of the social welfare Assam to examine whether the parties are residents of the center number 4 of Sadargaon Reserve Mini Anganwadi Center or not. Pursuant to the said directions, the Director of Social Welfare has inquired into the matter and has sought a report from the survey officer,
Program officer. Program officer.
program officer. Full stop. The program officer has submitted the report while
On 13
Concluding-
February 2015.
while concluding that the appellant is not the resident of center number 4 of the Sadargaon Reserve Mini Anganwadi Center, but is the resident of center number 85 of the Sadargaon Reserve Mini Anganwadi Center. It is also verified that the respondent number 6 herein is the resident of center number 85 of the Sadargaon Anganwadi Center. Full stop. Relying the Anganwadi Center. After receiving the report of, after receiving the said report, the Director of Social Welfare has summoned the appellant as well as the respondent 6 hearing. However, during the hearing before the Director Social Welfare, the appellant has failed to produce any documents in support of her claim that she is the resident of Anganwadi Center number 4 of Sadargaon Reserve, Mini Anganwadi Center. The Social Welfare, Director of Social Welfare, wide order dated 29/4/2015, directed to release the appellant from the service of Anganwadi worker at center number 4 of Sadargaon Reserve Mini Anganwadi Center, and has also ordered for appointment of the respondent number 6 hearing as Anganwadi Center worker for the said center. Full stop. Being agreed with the same, the petitioner, the appellant has preferred this has preferred the writ petition before the learned single judge, which came to be dismissed while impugned order. Hence, this appeal. Full stop. Learned counsel for the appellant has frankly admitted that though before the Director of Social Welfare, no documents have been produced by the appellant in support of her contention that she is the resident of Anganwadi Center number 4 of Sadargaon of Sadargaon. However, along with this writ petition, the petitioner, the appellant has annexed certain documents in support of her above claim. Full stop. It is contended that the learned single judge has not taken into consideration those documents and has illegally concluded that this court, that a writ court is not equipped to decide the cases, to decide the dispute raised, and only the civil court is the appropriate authority to decide the said issue as the same requires evidence. Full stop. Having heard the learned counsel for the appellant, we are of the view that the learned single judge has rightly come to the conclusion that the disputed questions of fact, particularly regarding the place of residence of the individuals, is a question which requires evidence, and certainly many a times this court is not equipped to decide such complicated questions. However, for our satisfaction, we have also taken into consideration the documents produced by the appellant along with the writ petition in support of her claim that she is a resident of Anganwadi Center number 4 of Sadargaon, Anganwadi, Sadargaon, of Sadargaon. Stop. After perusal of the said documents, we don't find any document which certifies that the appellant is the resident of Anganwadi Center number 4 of Sadargaon. Full stop. As in all the said certificates, it is only certified that the appellant is the resident of Sadargaon reserve area, but not concluding that the appellant is the resident of center number 4 of Sadargaon area. Full stop. In such circumstances, we are of the opinion that no case for interference is made out, hence the writ appeal is dismissed.
Much obliged.
Obliged, Lord.
The IA number so and so is also disposed of.
Obliged.
Lordship, may I take the liberty to mention that item 4, instead of second, could it be third? I have informed the other side also. I'm so sorry to mention.
Okay, 3rd of September.
3rd of September, item 4. Much obliged.
Item 10.
Lordship, I have informed by Mr. R. Majumdar that he has
Speak loudly.
sought for some instruction from the department, my lord, on basis of
Which
their,
instructions?
on basis of their affidavit in reply, my lord. So matter may be taken up on Thursday. Obliged.
Item 11 to 58.
My lord, in this series, basically.
Senior Advocate Nalin Kohli. I'm the Senior Additional Advocate General for the state.
Sir, kindly, please allow the counsel for the appellants to make some submissions, then we'll hear you, please.
Yes,
Wait.
of course, Lordship. I just wanted to say as a
Wait
matter
for
of
some-
just brief,
Wait for some time. please.
as Lordship pleases, as
Please.
Lordship.
My lord, in these cases, there are some, all are, some are ACS officers, some are Assam Police Service, some are Transport Service.
Three type of person.
Yes. Well, basically, there is an allegation that there is entry into services tainted with some wrongdoing and all. So basically, they were discharged. But our allegation before the learned single judge was that this discharge order was based on some allegations. Police report.
Stigma attaches to it.
And therefore, yes,
The principle of natural.
justice was not followed.
That I-
Basically, my lord, our case was, since it is founded on allegation, therefore it's not a case of a termination simpliciter, but it's a case of termination when Articles 10 and 11 is attracted.
Certain arguments were also raised
Yes.
that they were deemed to be confirmed and therefore.
Yes,
300
those are also there. Now, whatever has happened, my lord, then against the order of the learned single judge, we preferred this appeal.
Fine.
Now, if a lordship would kindly come to order dated 29/9/23,
That is SIT.
Now, I think the government will have to respond to this, my lord.
That is right.
That is how the matter is placed.
That SIT, what are those findings of the SIT on these 4 or 5 points which the court has?
Yes, my lord.
My lord, what I'll just add to it. This, my lord, will kindly see 29/2023 order. When this particular matter, before the appeal it was moved, I actually brought notice to the court one more additional point. We said that on the basis of a police report where discharged, we have been discharged. And you segregated tainted and non-tainted. Now, we being tainted, we have been discharged, non-tainted remains. We brought notice before the appellate court.
But
Look
some
here,
persons are also.
yes. So how you
Falls in
that-
that category also.
so now we said the entire police report, which you said entire should go. It is all, this is one. So all tainted that police report. Now on that basis, we demonstrate before the court certain document which he received under 207 before the learned trial. We placed before this honorable court with the appeal. And that was looked into by the court. And the observation of the learned division bench was,
Certain
your
expla-
lordship kindly see, this is what has happened.
Certain explanation has been asked from
Yes.
the SIT.
Yes.
That was formed on 28/9/2023 to clarify on 4 points.
Yes, correct. Now, maybe they have to place it the report before this. one.
If they-
But now,
When once the court has asked for it, they have to.
now what has happened, my lord? They invest, now I came to know from my junior who is before the learned trial court. The investigation, they have, SIT was formed. They investigate the matter. 6 more, candidates were being charge sheeted. 6 more candidates. Yeah, five. So they were placed before this, the learned trial court. Learned trial court was not very with the investigation, not very happy with the team they formed. So they said, no, we are not happy with the team. So another team was again, IO. They replaced the IO.
Okay.
And this is what we have come to know. We don't know what is the stage now. But our whole case is that what my learned friend has projected.
Remains to be taken.
So this, today also it remains to be tainted. So what type of investigation you have done? And you have segregated tainted and untainted, apparently on the face of it.
Some
That-
persons who are also tainted.
Then what is the,
That's right.
so this and my learned.
I think in the 3 or 4
Yeah.
points, which was,
That is very much.
I think they'll have to answer
Yes.
first, my lord, before proceeding in the, that would be our humble task.
Now let them ask.
I am appearing for item 12.
Yeah.
Item 12, my lord, here I say that, my lord, there were some errors apparent on part of the findings of the learned single judge, in as much as those findings were without basis. Blanketly roped in persons including me, and my lord, the police report said, and his learned single judge said that I made a statement under 161 before the my lord investigator. That is not correct. On record, that is not correct. So made some sweeping comments and roped in my lord without segregating my lord case to case.
And here to every case along with that.
And the main arguments, my lord, I think Mr. Das told me, I also submitted last occasion, those will remain. Main argument, whether police reports can from the foundation, and moreover, the order said you are not fit for, that is another.
So that's why only the appeal is here.
Yes.
That we then will consider. Now, yes, Mr. Kohli. Yes, Mr. Kohli.
Lordship, yes, Lordship, I'm so glad. Lordship, there was an form and we had not filed the latest developments because this matter came up rather suddenly. Now, Lordship may permit us to bring on record the entire developments since then because several people have been arrested, and further, Lordship, there has been a development in the trial court, there has been sentencing also. I was only going to propose, subject to Lordship's convenience, that I happen to be in Guwahati High Court on the 3rd of September for a matter. If Lordship would be pleased, I could be there to personally assist Lordship. I will file a report before that, and then Lordship may decide what needs to be subject to law convenience.
What about this order of this court of 29/9/2023, where this SIT was asked to finish some explanation on 4 points?
Lordship, so one, I'm told in the cover has been filed. Lordship, that has been filed. And then that's why I was saying if Lordship would give me at least a week, I will bring on record the latest position, not only answering these questions, but the development of the investigation thereafter in a sealed cover before Lordship. And that's why I was proposing third September should still be.
Any other date, other than September 3rd? Any other date except September 3rd? Mr. Colley,
Oh.
yes, Mr. Colley,
Link has gone on.
who is assisting Mr. Colley here?
Yeah.
Ask him any other date. Not of 3rd of September, because this bench may not be available or at some commitments at Aizawl also, from 4th.
Let it be thereafter. After.
Let the date, confirm you have to get the nod of the other side also. Both the parties are required to be. Though I have to leave on 4th only, but maybe 3rd on some.
I think now he is audible.
Yes, Mr. Colley, any other date than 3rd of September?
Lordship, I'm actually hardly thinking third both days of convenience, otherwise any other day, Lordship.
So you are not audible.
17th.
You are not
17th, Lordship.
17th.
Yes, Lordship.
Yes, 17th September.
So,
17th is the Tuesday. Yes, okay. Okay. This report was ordered dated 29/2023. It's directed the respondents
No.
to
একেখিনি allegation দেখা কোনোবা জেলত আছে কিবা চাকৰি কৰি আছে
produce an interim report in a sealed cover on certain points which were formulated in the order itself. Mr. Naveen Colley, then it's appearing for the respondent's name is submitted that the required interim report would be produced along with the other documents as directed by this court on 29/9/2023 by the next date of hearing. With the consent of the parties, list these matters on 17th of September.
Just highlight the scene.
If the copy of the report, my lord, if the copy of the report is furnished before the court, I think we should also get that copy in advance.
The court has asked to submit the report in sealed.
Yeah, Lordship,
Okay, fine. Let
just
us-
submit that.
No, no, then
Lordship
your lordship will take it.
Decide.
Then your lordship will call it. Yes,
Yes.
I'm deeply.
Item 60.
Deeply
Similar to this group, my lord.
Same.
Same, my lord.
So why it is?
It's corrected.
Why it is segregated? Why it is segregated?
No, my lord, I disagree.
Just along with that bunch का इसमें 60 में ये order कर रहे हैं.
60 also, my lord.
60 years.
All right.
Grateful.
Yes.
Item 61.
Your Lordship, Mr. SCKL is appearing on behalf of income tax. So he's in court, he's in legs in court number 21.
Pass over to the time.
Item 63.
I'm for the respondent one.
Please, your lordship may kindly take it up this matter on next week on Thursday. My senior is in another court, my lord.
They were pressing for time.
Is there any stay?
Yes, my lord.
No, lordship, your lordship has molded a question that whether the DRT can condone the delay in a
that's
matter under section 17 of the SurfaceCA Act.
fine.
In this case, what happened, lordship? Under the application was under section 17 of the SurfaceCA Act. Now that was barred by limitation. The learned DRT rejected the SurfaceCA application
On the ground of this.
limitation.
Fine.
Now, there is settled law, lordship, that section 17 is the original jurisdiction of the honorable DRT after the Murdia Chemicals case. It was previously an appeal. Now, after the Murdia Chemicals case, it has been amended and it's an original application. If it is an application, lordship, and it is an original jurisdiction, whether the condonation of delay is applicable.
That may be, you are correct, but the another question is whether any person can be left remediless for that reason, because for whatever reason, the tribunal has no power to condone the delay. Then where the person would go, sir?
No, that is the lordship. Previous to this one, SurfaceCA Act, the person could have gone to the civil court. Lordship will take this aspect of the matter. Now, SurfaceCA Act debars the civil court's jurisdiction,
Fine.
as your lordship knows. Now, the prime motive of enactment of the SurfaceCA Act, lordship, is a speedy disposal. If the power of condonation of delay is allowed, now there would be not ending of the matter. That is why, lordship, in Murdia Chemicals case, it is specifically held that section 17 application is in lieu of a civil suit, and it is an original jurisdiction. Thereafter, in transcore also, lordship, similar view has been made. Thereafter, in
The question is whether this, since certainly the tribunal has no jurisdiction to this condone the delay, and there is a bar
under section
for the
34.
Civil court to entertain any proceedings in that.
Yes,
In that situation, in a given situation, whether this court, while exercising powers under Article 226.
lordship, no, because there is an appellate forum.
Appellate forum for what?
Because if the lordship
Appellate forum,
under
Appellate tribunal,
yeah,
section 18.
yes,
But since the time barred is, this application is time barred, how this tribunal can exercise? its
because this honorable court held in other cases, lordship,
Yeah.
in similar case, sort of matter.
Then the tribunal can entertain even a time.
No,
barred, Application.
Lordship, the question of condonation of delay,
Yeah.
question of condonation of delay, that is an order passed by the learned tribunal. This honorable court held that this is an order passed by the tribunal. So the appellate forums goes to DRAT. That is one aspect of the matter, because if a person is aggrieved, it is go to the DRAT. In that view of the matter, this honorable court in the division bench of this honorable court in Imtiaz case, Ali's case, has held.
In a time barred this matter.
Yes, lordship.
What is that?
The lordship is here. My lord, if your lordship is hearing of the matter today, it can be.
Yeah, we are just contemplating, sir. We are,
My lord.
will grant you the time.
My lord.
Let us clear.
My lord.
No, it says that the appellate tribunal.
No, I was just to appraise your lordship, but I leave it to your lordship because on the,
Very well challenge that order whereby the application is dismissed as time barred. But now the question is whether the tribunal can condone the delay or not.
no, tribunal cannot condone the delay.
No, tribunal cannot condone the delay. So the result is that the person or the agreed person would be remediless.
No,
In
lordship,
that
this is a specific lordship where if this, if your lordship comes to an otherwise that the tribunal can condone the delay, then there will be the entire purpose of the SURFACE Act will be meaningless. That is what, because this is an original jurisdiction. Now lordship, taking for example as a civil suit. Because of the SURFACE application under section 17 of the SURFACE Act is in lieu of a civil suit. Now, whether we can file a civil suit after being time barred. A civil suit has to be filed within a specific time. The limitation is there. Whether we can file a civil suit at any point of time after giving application under section 5 of the Limitation Act. That is not.
the claim is time barred, it will remain time barred.
Yes, lordship. And that is the main motto of the SURFACE Act itself. It is a spirit disposal.
Let us begin at consent for the appellant, the petitioner. Wait for short accommodation. Just after 2 weeks.
2 weeks. Obliged, lordship.
Supplementary list item 64 to 69.
Wait, Vijay.
Yes.
So. My lord, I'm appearing in item number 64. My lord, basically we are assailing the constitutional validity of the.
Item number 64, this.
Yes.
2596.
And my,
Challenge is to the ordinance itself.
Yes. Yes, basically it's the same. Now, if your lordship would kindly.
So, Chaudhary, the problem is, even though we'll hear this matter today, we'll not be able to pronounce the judgment today itself.
Yes.
That's the problem. In the meantime, yes, we can do one thing. We can fix it on 27th or 28th. At that time, if this bill or this act is not passed or not enacted.
No, my lord, my lord, if your lordship would kindly have article 213 for a moment.
Yeah.
Why not laying of the ordinance before the parliament, that is the second link. I'm on the first link. If your lordship would kindly come to 213. If at any time, as a lordship's law. If at any time, except when legislative assembly of a state is in session, where there is a legislative council in a state, except when both houses of the legislature are in session, governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require. Provided that governor shall not, without instruction from the president, promulgate any such ordinance, if we are not concerned with that proviso, now please come to 2, my lord. An ordinance promulgated under this article shall have the same force and effect as an act of the legislature of the state assented to by the governor, but every such ordinance shall be laid before the assembly of a state or where there is a legislative council in the state before both, and shall cease to operate after expiration of 6 weeks from reassembly of the legislature, or if both the expiration of that period, a resolution disapproving it is passed by the legislative assembly and agreed to by the legislative council, if any, upon the passing of the resolution, or as the case may be, on the resolution of being agreed by the council, may be withdrawn at any time by the governor. So, my lord, we are not concerned with the situation envisaged in sub-article 2. So, my lord, that is a separate, there's an additional aspect within 6 weeks of the assembly. If it is not brought in, then it will lose its force. Now the question is, in this case, lordship knows whenever a power to make any law by way of ordinance is resorted to, then in the language of the Supreme Court, it is called, my lord, legislation by the executive. That is not their primary function. The primary function of the legislature is to make primary legislation, plenary legislations. Now the question is, my lord, what was that urgency which impelled the governor to issue this? Now there, my lord, lordships will have to go by the judgment of the Supreme Court in that Bihar case, Wadhwa's case, where Supreme Court said, my lord, it must be spelled out. What was the urgency? And the only urgency we can see was the election to the Lok Sabha. So that is a political expediency. So, my lord, Supreme Court has taken note of all these things. In Asar Chaudhry's case, Hirapu's case, Supreme Court says it can't be done. Government has to be government according to rule of law. Now, here in this case, my lord, the government will have to place on record the satisfaction of the governor on that relevant point of time. What was that urgency which, why that satisfaction was recorded? There is an immediate necessity.
It must have spelled out in the.
Nothing, my lord. If it does not say so anything. Please see, my lord. They give 3 reasons. Those are reasons are generally. Please see, look at their affidavit, my lord. In the lordship, kindly take the repetition at page 54. I don't download it. 54. Government. Itu amar ki city disile niki. Yes. Lord will kindly come to page 54 of the petition. Now, this is the cabinet, decision, my lord. Please come to repeal of the act proposed for the following reason. It is an obsolete pre-independence act of British for the then province of Assam. The registration of marriage and divorce is not mandatory as per the act, and the machinery of registration is informal, leaving a lot of scope for non-compliance of extant norms. As per the provisions of the act, there remains scope for registering marriage of intended person below 21 years for male and 18 years for female, and there is hardly any monitoring for implementation of the act. My lord, these are the 3 reasons which they have given. Yes. Now, my lord, if something is permitted by the personal law of the section of the citizen, then what would be the position, my lord? My lord, as per the Mohammedan law, my lord, which has been accepted by the Supreme Court also, my lord, after attaining puberty, without attaining 18 years, a Muslim woman, girl, can contract a marriage. Similarly, my lord, in case of boys or man, my lord, below 18 years also, they can contract a marriage. So therefore, that is something, permitted by their personal law. And in terms of Article 25 of the Constitution of India, my lord, the religious practice, religious belief, these are all protected. But the question is, my lord, if you want to bring a law which hurts the personal law of the person
Now
concerned,
the question is
yes,
that this Child Marriages Act 2006
Yes.
is in clear conflict with this whatever the other act, provisions of Act 35.
Yes.
Which act will prevail?
no, my lord, Supreme Court says in case of conflict between any legislation and personal law, it is personal law that will prevail, my lord. My lord, we do not have an uniform civil code till then. Tomorrow, if it is there, then thing would be otherwise.
That's the matter.
So if we go by the spirit of Article 21, my lord, that the personal law will prevail. Oh, lordship, even otherwise, only in respect of secular matters, my lord, state can make legislation. As far as the religious practice, religious belief, there, my lord, that is the fundamental to the person. It cannot be regulated by any law.
That what you are arguing, some of the
Anyway, my
experts
lord,
take a different.
That will be a larger debate. But what I propose to do for lordship's kind consideration at this stage is, let government will have to satisfy, my lord, what was the urgency involved in this case, for which, my lord, this ordinance had to be promulgated.
What is the response to the?
Yes. My lord, as far as urgency is concerned, to be, my lord, I find nothing in the affidavit.
Let us see.
But let us, yes. My lord, we. My lord, I'll draw your lordship's kind attention to two paragraphs. Please come to para 7 first, then para 10. That the at page 78.
78.
Yes.
This is
My lord, 78 is a part of the affidavit filed by the state, my lord.
yes.
Para 7.
Yes.
That the deponent states that section 10 of the Assam Muslim Marriage and Divorce Registration Act 1935 permits registration of marriage of minor child by their lawful guardian, which is contradictory to the prohibition of the Child Marriage Act 2006. The Central Act, which prohibits solemnization of a child marriage, provide rigorous imprisonment, which may extend up to 2 years of punishment, and fine, which may be extended up to 1 lakh of rupee on persons whoever perform, conducts, directs, or abets any child marriage, whereas Act of 1935, which allowed child marriage and thereby directly repugnant to the prohibition of the Child Marriage Act 2006. The repealing ordinance, being a step to rectify the drawback, is therefore legal and valid. The Assam Muslim Marriage and Divorce Registration Act is also violative of the provisions of the Children from Sexual Offence Act of 2012. The Central Act specifically enacted for protection of children from offences of sexual abuse and harassment. Provision of Section 10 of the Assam Muslim Marriage and Divorce Registration Act 35, which permits minor to marry and allow lawful guardian of a minor to sign in register for registration of the marriage, is directly in distinction to the POXCO Act, particularly Section 3, 4, and 11, and abatement of the same under Section 16, which are punishable as per Section 7, 8, 17, and 18 of the POXO Act. Moreover, Muslim marriage in the absence of Assam Muslim Marriage and Divorce Registration Act 1935 can be registered under Special Marriage Act, and a provision to Section 40 of the Muslim marriage may be solemnized within the degrees of prohibited relationship. Then Milord will kindly come to para 10 at page 81. That the deponent begs to state that as per Rule 20 of the Assam Muslim Marriage and Divorce Registration Act and Rules 1935, the fee received by the Muslim register under Section 9 and 15 of the Act and by Rule 52 may be retained by him as his lawful remuneration.
Muslim registrars and the Qazis are the same thing.
Same. In fact, my lord, as of now, there is no Muslim register. That function is being performed by the Qazi.
Means they are the
Yes.
registrars.
Yes. In this way, the revenue foregone on account of stamp duty and registration fee for registration of marriages under the said act was the financial burden on the state. it is most pertinent to mention herein that due to urgent situation to stop registration of marriages below 21 years for males and 18 years for females, the issuance of impugn ordinance was very much necessary. Accordingly, the ordinance has been brought to greater interest for the citizens of Assam, more particularly to stop child marriage in the state of Assam. My lord, they have tried to cover up this urgency part by this. Hello, where are the empirical data? Hello, Lordship knows, Honorable Supreme Court has repeatedly said, whenever you bring up any legislation alleging some factual background, then you must come up with the empirical data. In fact, my lord, some of the Qazis were arrested. Apprehending arrest, my lord, they filed anticipatory bail. Now, in those cases, my lord, even they could not even cite a single instance.
After 1.5 years.
Now the question is, I am on my first limb of my argument, my lord. My articulation of my argument today is very simple. All that I am saying is, what was that urgency which impelled the governor to record the satisfaction that we cannot wait till the sitting of the next session. Therefore, there is a requirement of, invoking the power under 213 to bring in an ordinance. What all are the figures? The affidavit must disclose. The fact that affidavit is not disclosing anything in my humble submission, it means they do not have any facts to place before this honorable court. End of the day, my lord, apart from anything else, these are all very sensitive issues. So one has to handle with a lot of care, my lord. End of the day, we are a secular country. The Constitution has laid down the broad principles. So here we are not supposed to. In fact, my lord, recently there is a judgment of the Punjab and Haryana High Court. Of course, that is on merit. My lord, let me first place my point on that there was no urgency. Dear my lord, I will first have your lordship's kind attention to the honorable decision of the Honorable Supreme Court. Yes. If your lordship would kindly come to page 57, where the Honorable Supreme Court was dealing with a matter. If your lordship would kindly come to page 62. Why the legislation is still relevant, my lord? Page 62. I'll have your lordship's kind attention to 3 paragraphs, 16, 17, and 18. Lord will kindly come to page 62, para 16, 17, and 18. Has your lordship got it, Miller? Page 62, para 16. As a natural consequence, the effect of non-registration would be that presumption which is available from registration of marriage would be denied to a person whose marriage is not registered. Accordingly, we are of the view that marriages of all persons who are citizens of India belonging to various religions should be made compulsorily registrable in their respective state where the marriage is solemnized. Accordingly, we direct the state and the central government to take the following steps. Procedure for registration should be notified by respective states within 3 months from today. This can be done by amending the existing rule, if any, or by framing new rules.
Just a minute.
Next para.
Page 64, continuing portion. আমি করি তো। Stated portion. 23, হ্যাঁ। কিন্তু কেতিয়া কৰিলে? 2010.
Let's, before going into the further merits of the case, Mr. Sekia. If your affidavit is there, you have shown some urgency, or would you like to supply or some additional facts which force this governor to take this order?
Yes, I can give the figures regarding the,
Would you like to give further details? or
yes, Lord.
These details are sufficient for that? reason?
From one point of view, it is sufficient, but now my friend was mentioning about the empirical data and all. So empirical data I would like to furnish.
Those data were placed before the honorable the governor?
That I have to see the file, because in our affidavit, we have very categorically said there are various aspects. One is the large number of,
You have touched this aspect, but not in detail.
yes, we have touched it.
You have mentioned that this is what the.
Absolutely. And these data are available with us.
Would you like to furnish them, then only we'll proceed, otherwise.
I would like to, because they are raising this issue regarding the empirical data. Empirical data only regarding the arrest of Qazis are here in my affidavit. But I have to furnish the requirement of this from the point of view of the infant mortality rate, the mother's mortality rate, all these things I have to place. Why we are going to crack down the child marriage? The basic concept is to that.
Then you have to explain that his mortality rate increased suddenly.
Suddenly in certain pockets. When we find a young girl of 18 years being the mother of 4 children, we have those data also. When they should go to college, they are going to the, yeah, the additional data I will like to furnish.
27th only.
One second, Lord.
Just one. To just project two things, man.
Yeah.
Otherwise, I am, the urgency is here.
Sorry. Well, only thing is, my lord, only thing is, lordship will protect the subject matter, otherwise that tomorrow nothing. Some status quo as on today be maintained.
That would be very difficult. We can't restrain the.
No,
whatever
lordship,
the
no,
legislative
lordship will
business.
not restrain the legislature from, this is their business.
Well, consider it, then.
Only thing is, my lord, lordship, only thing is, lordship will make an observation. If necessary, lordship will pass an order, which should be status quo ante. If lordship makes that position clear, then also it will serve.
Consider.
Yes.
That we will consider, but now at this stage. sir,
At least lordship will keep that
would be-
prayer
would
open.
be
Yes.
My lord,
somewhat.
I just want to place 2-3 things, my lord, for
Yes.
lordship before. My lord, my learned friend has shown 213, when an ordinance can be issued by the governor. But there are two issues here, what I found. If your lordship has, my learned friend has read that provision, what is most important in this case, to issue an ordinance by the governor, my lord, is, your lordship will kindly see 213 again.
Yes.
213 for your lordship consideration. One, if at any time except when the legislative assembly of a state is in session or where there is a legislative council in a state except when both houses of legislature are in session, governor is satisfied, circumstances exist which render it necessary for him to take immediate action. So, my lord, your lordship recollect, in a Nirbhaya case, that was an ordinance was issued somewhere in 2012, because that circumstances exist at that relevant time. But here,
It was a very debatable.
no, but
question. That is a very debatable.
no,
question.
this issue,
Because this Nirbhaya issue was triggered on account of or whatever.
I-
whatever
this-
reason, but otherwise also, that was not the situation that in the whole of the country,
no.
immediately, that
I-
was the
I-
first
the-
incident. And no such incident has ever
My lord-
took place or whatever it may
See,
be.
my lord, two issues. Here, either you have the judicial intervention by the Bihar case is either fraud on power or oblique motive, ulterior motive. Now, if you see,
Looking to this.
no, my lord,
Kolkata
there are two
case,
things, your lord.
If any ordinance.
This act,
comes, then-
I'll just give a reply. This act is of 1935, 1935 act. Now, there are three grounds which the cabinet has taken in the month of December. One is a absolute pre-independence act. My lord,
It was
this is a
incurrency from
issue.
last so many years, so that may not be.
my lord, that cannot be a
urgency.
ground,
That can't be a case of urgency. Yes, I
urgency.
agree that.
Number two, child, it's not a compulsory registration. Not a compulsory registration. That what I'll say before your lordship, after the SEMA judgment of the Supreme Court in
That
2008,
amendment was brought in.
all it is, now that 1935 act, they amended by virtue of 2F and it made compulsory.
Compulsory, yes.
Now, so, my lord, if the, and the stand which is taken, and it was placed before the governor, is totally something else. If you see the,
Only sir, we have asked them to, if they want to furnish some further details, then
Oh.
what was the urgency
right,
which compelled the governor to promulgate this ordinance? That's why only if they want to furnish some details or they're
my lord, the
happy with it.
session was there till February. 15th of March 2024, ordinance was issued. Very well, it should have been debated if 1935 Act, now it taking a plea of POSCO, which is of 2012, and the prohibition of child marriage 2006. They could have, my lord, waited and put a debate in the House in this particular issue. They have not done it.
But only sir, we have
All
asked
these
them,
are-
if we want to furnish further details, furnish it.
And
Otherwise,
today-
we'll consider it.
Correct, your lordship, today, that is why I moved the matter, your lordship, just recollect. Only is that today, 1935 Act, any divorce which should take place, we are in big limbo, we can't do anything. Now, they said there is a legislation, Special Marriage Act. My lord, your lordship knows the Special Marriage Act, a registration which has taken place 1935, a divorce cannot take place under Special Marriage Act. It is by way of that act only. Today, the women, whoever are suffering, because there is 1935 Act, how a 1935 Act prohibited degree, whether, how can I do it under the Special Marriage Act? These are the biggest problem, my lord. They have got every right. I do not say an act can be made.
Yes.
It is their prerogative.
Yes,
Your lordship will
those
not
grounds
question
are-
it.
Those grounds are also very relevant. But for that purpose, first of all, if you, the state is not able to satisfy us that there was any urgency, then where was the need to go into all other?
That's not-
This
My lord,
argument.
apparently, on the face of it, with great respect, I am saying that there was no urgency
That's
for
why only,
issuing the
sir, we have
ordinance.
simply asked them, and Mr. Chaudhary has also pointed out this. If you want, Mr. by 27, we'll fix it on 27.
Urgency, leaving apart everything, there is a judicial order that triggered the government. Because all our, I'm not disclosing all my cards today.
Whatever it may be,
Yes.
we are not disclosing, and please keep your cards with your, up to your chest. And place it
Because
on
they are avoiding, because they read the affidavit, but the main crucial part they have left.
27th, we'll fix it on 27th.
His lordship kindly give me 3 more days because the assembly session is going on. So that is why I'm asking, requesting for 3 more days.
How much, which date you are?
Could it be on 2nd of September, lordship?
2nd September, then it will be.
It's a Monday.
In August, it's
28? 28, 29,
30th of August.
30th.
30th, lordship. Perfect. Perfect.
This one, 30th of August.
Passover meter,
Deeply
61.
Okay.
Yes.
Your Lordship, I have been instructed by the senior, the returns filed by the SSC is an old one. So at that time, the online facilities were not there. So your Lordship may give direction, will get the report available.
Which report?
Madam, in this matter, the TDS was deducted by this honorable court, registry of this honorable court, and the office of the Loka Ayukta, madam. The petitioner was a serving judge of this honorable court and Loka Ayukta. So, madam, they had deposited the tax TDS before the income tax department, madam.
Fine.
Now they are demanding the same for 4 financial years amounting to rupees 8,40,000.
Fine.
So, madam, your Lordship may direct the department to take the affidavits of the Loka Ayukta as well as the registry of this court into account. And there are,
Why, registry of this court?
madam, they have filed their affidavit. Page 67, madam. Operative portion at page number 69, madam.
What it says?
Madam, may I read, madam? That the deponent wishes to state that the writ petitioner joined as a judge of this honorable court in the month of October 1997 and demitted the office of judge of this honorable court in the month of August 2007 against the bill of amount of rupees 257,670 in respect of aerial pay and allowances with effect from so and so. An amount of rupees 77,301 was deducted as TDS, which is clearly reflected from the statement of the bill register prepared by the Treasury Officer.
Fine.
And thereafter, madam, the Loka Ayukta has also filed their affidavit at page 60.
Reiterating the same.
Madam, page 60.
So now what do you want? Yes. Now
Your
what-
Lordship, we need some time
For what?
for getting the information available from the department.
The department, they have already mentioned it that
Madam,
by so and so voucher, we have already paid it. That
Madam, the representative of the petitioner had also visited the department, madam. They had said that the records have some problem. They have some problem with
where
the.
is Mr. Dayal?
Mr. Kayal is on legs in port number 10.
By the next step, you please clarify it. Once it is already deducted and deposited, then there is no need to issue notice to it.
Lordship. Lordship, a short date may be fixed.
Okay. Mr. So and so for Mr. Dayal. Waste some time to ascertain whether the TDS deducted. Ascertain that as per the state doctor, Guwahati High Court as well as the Loka Ayukta, Assam, the TDS has been deducted from the salary account of the petitioner or not, and is or not, that's all. List on 12th of September.
Madam.
Highly
Details.
May I please, Lordship? At item 63.
Yeah.
That you, Lordship, I will actually say I will like another court, my lord. So my juniors submitted that it will come next Thursday. So your Lordship was directed to list after 2 weeks. Can it be on 29, my lord, next Thursday?
29.
29, next Thursday?
29.
My lord.